Copyright essentials to success. Whether you're starting out in business or creating new products and services for your existing business, you'll want to make sure that you're doing things right, that your actions will set you up for success. Unless you're purely testing the market, that is, in a way where none of what you create needs to endure or be relied upon longer term. It otherwise pays to be mindful of the longer term implications of your early actions when you're implementing ideas. If you're thinking big and aiming to create a business to one day sell, you definitely need to pay attention to what I'm highlighting here. Now, setting yourself up for success involves being aware of how assets are created under the legal system and the pitfalls to avoid. You should aim to implement your ideas in the right way because it's the very early decisions and actions that you take before you would even consult a lawyer that have the greatest risk from a business perspective. Copyright is essential if you want to create assets that will grow in value as your business becomes more established. It crops up in so many different ways. Aim to understand the essentials and avoid attracting liabilities, such as by using other people's content. Here I explain just some of the copyright basics, some key concepts that aren't generally well understood. However, you need to know more than this. So what copyright covers? There's quite a lot of confusion generally with intellectual property terms like copyright, trademarks, patents, designs. You need to have some understanding of these terms as they're a type of property that it's possible to own just like land. Nowadays in the digital economy, they're so important. Copyright, like other IP rights, is intangible. That means it's a property right that's attached to something else. So, for example, you buy a book, you will own it, but you do not own the copyright in that book. The copyright belongs to someone else, the author or publisher perhaps. So copyright ownership will often be separate from the physical object. The same principles apply to intangible objects such as logos or websites. Clarity about the fact that copyright is separate from the physical or intangible product that you may be using or having created for you helps in understanding it. The creator of a copyright work is the one who owns the copyright in that work, and that copyright lasts their lifetime plus 70 years. That's a long time. Just like any property right, copyright may be sold, left in your will to your heirs, mortgaged, licensed to other people to use. So the owner of copyright is the person who can grant permission, license, to others to use their copyright work. They control who uses it and for what purposes. Just like the owner of land decides who to rent the property to, whether to give permission to someone to use their land for a particular purpose, and so on. The types of copyright work which are potentially relevant to individuals and businesses alike include books, brochures and written content, music, films and videos, photographs, drawings and illustrations, logos and packaging, computer programs and games. You get it basically. So to conclude this section, the copyright in objects is separate from the object itself. What copyright isn't? Now, not everything is protected by copyright. For example, it only protects a work that's fixed in some sort of tangible form, such as when it's written down. So copyright doesn't protect ideas, methods, names or taglines. It's mainly because the legal system has decided as a policy decision not to let names be protected by copyright, but instead by trademarks. So copyright protects an idea, doesn't protect an idea, it protects the expression. This is the idea-expression dichotomy. So the fact that copyright doesn't exist in ideas has a number of ramifications. For example, let's take a copyright work like a food recipe. The words of a recipe are what copyright protects, rather than the ideas contained in the recipe. That means if someone sets your recipe out in their book or copies and distributes it, they'll be infringing your copyright. As for the ideas embodied in your recipe, so obviously it's not infringement to cook whatever the recipe covers using every idea from the recipe. So if it's a recipe for making rabbit pie, you can make rabbit pie to that recipe, sell the pies commercially, you can cook your own version of rabbit pie, whatever. So you can even publish your own recipe based on the ideas you get from the other recipe. There's no copyright infringement involved as long as your recipe isn't a word-for-word copy of the original recipe with one or two minor changes. So they should express their ideas in a different way and not slavishly borrow from you. Unfortunately, this neat categorization has become murky due to some cases that have been decided by the courts. Now, sometimes people wonder whether they might be infringing on someone's copyright if over many years they've studied a topic, attended courses, books, developed their own way of working. How can they be sure that it's their own IP, so to speak, that they've developed from all their learnings and that they're not infringing on other people's copyright? Should you be giving credit where it's legally due? There is no categorical answer to whether someone is crossing the line between drawing inspiration from a copyright work and copying, that is, infringing copyright. At both ends of the scale, it will be very clear. So there's no copying when somebody has simply got ideas and drawn inspiration from the ideas embodied in a copyright work and gone and created something of their own. So they haven't copied the expression, just the idea. At the other extreme is where there's widespread copying of the actual source material, word for word copying of the majority of the work. Now, when it's not clear cut, then an experienced copyright lawyer may be able to guide you, but ultimately, if it's really borderline whether there is copyright infringement or not, this is ultimately a question of fact for a judge. There's no ready formula that says if you have X% of a work copied, you're infringing. There have been cases in the UK where the minutest percentage copying has amounted to infringement. This involved a musical piece which copied a very distinctive element of it. On the other hand, there have been cases where whole sections of a book were copied and it wasn't infringement because the material was deemed to be quite generic. So where a dispute arises, the issue is generally negotiated between the lawyers and some sort of compromise is usually reached to reflect the rights and wrongs of the matter. If no resolution can be reached, then ultimately a judge would need to decide the issue. But remember, we stand on the shoulders of giants. There is no completely original thought. So if you've developed your ideas, drawing from a combination of sources, then it's more likely than not that it would be your own IP. It's often a good idea to list sources in a bibliography at the end of your book. So in conclusion, copyright is just one of the intellectual property rights to be aware of when implementing ideas. There are in fact other aspects of copyright that your business should protect itself against. Here, I've just touched the surface so as not to overload you with information. Who owns copyright and how you secure copyright ownership is the other really important practical point to grasp about copyright and to remember to address throughout your business life. I cover this fully in the mini course that I've designed. Just use the link and go and have a look into it. Do yourself a favor because this is so important as a risk to manage in your business. Alternatively, if you want to discover other aspects of copyright as well as other intellectual property risks, then the Legally Branded Academy is the online course for you. It includes copyright ownership and much more. Find out more about it. If you buy before mid-2019, then you'll get it at half the price because the price is going up when the revised course is out.